For judgment item 1, second appeal 334 of 2017.
Both the substantial questions of law having been answered in favor of the respondent and against the defendant number 1 appellant, the second appeal is dismissed.
Item 2, second appeal 52 of 2022.
The substantial question of law as framed is answered in favor of the appellant, and consequently the improved judgment is satisfied. To the extent it relates to the substantial question. This appeal is allowed.
For final disclosure, item 3, second appeal 37 of 2021.
First, Lordship, I will be addressing issue number C. If Lordship I succeed in this issue, the other issues Lordship will not be able to.
That is regarding the second substantial question.
Lordship, whether the entire plant is itself is hit by the provision of Order 7, Rule 3, that
Order 7.
which was formulated on the last occasion.
Yes, that's right. Last order की copies हैं.
अगर ये succeed होगा
Last order अपलोड हो चुका है.
नहीं हुआ.
लेकिन हम लोग तो ओपन कोर्ट में किए थे.
हाँ हाँ.
वो ऑर्डर साइन हो चुका, अपलोड नहीं हुआ. So आइए था ना.
आइए था.
आइए था वो
number.
substantial question of law.
आइए number I am going to 2115. C, Lordship.
हाँ.
Lordship got that.
Order 7, Rule 3.
Lordship. First of all, Lordship, I will be placing two provisions of CPC, Lordship, so that we will understand what these two provisions mean, Lordship.
आइए के जो B and C था ये हम लोगों ने प्रिंट किया.
Hi, he is away.
You were there?
Yes. They are
Yes,
away.
please.
First, Lordship, is Order 7.
ये ऑर्डर देखिए अपलोड होना चाहिए. इसको करें. Order 7.
Rule 3.
Yes, please.
Where the subject matter of the suit is immovable property. Here also, Lordship, the subject matter is a portion of a land, Lordship, house constructed there. Where the subject matter of the suit is immovable property, the plaintiff shall contain. Lordship got that?
Let me just get
Lordship.
Rule 3. Yes.
Lordship.
Yes, please read it.
Where the subject matter of the suit is immovable property, the plaintiff shall contain a description of the property sufficient to identify it, Lordship. These words are important. And in case such property can be identified by boundaries or numbers, boundaries and numbers, both are important.
Boundaries or numbers?
Or numbers.
Alternative.
I'm considering both. Even if one of them is there, it is in their favor. Boundaries or numbers in a record of settlement or survey. The plaintiff shall specify the boundaries or numbers.
If there are boundaries and numbers, the plaintiff should Specify that.
Specify that. Has to be because Lordship, unless until the
Identity is there, otherwise it will be a vague decree.
yes, Lordship. Vagueness because to
इसको राकेश जी को दे दो। राकेश जी तो यहीं बैठे उनके टेबल पे रखो।
Thereafter, Lordship, one more provision related to the same Order 20, Rule 9, Lordship. Order 20, Lordship, deals with judgment and decree. And why this is important? That is specified, Lordship, in Rule 9. Now, here also, Lordship, they have pleaded for recovery of possession, Lordship. It is an admitted fact that we are in possession, and therefore, Lordship,
Appellant is in possession.
we are in possession. And therefore, recovery of a cancellation of a sale deed, and thereafter, Lordship, thereby declaring their possession and consequently recovery of possession. Decree for recovery of immovable property. Where the subject matter of the suit is immovable property, the decree shall contain a description of such property sufficient to identify the same, and where such property can be identified by the boundaries or by numbers, same thing. In a record of settlement or survey, the decree shall specify such boundaries or numbers. Now, Lordship, my first question in this is, they have a plaint, they have specified something in the plaint.
Whatever it is.
Yes, Lordship. And they have come for a cancellation of a sale deed, which they have not exhibited.
Okay, you must have exhibited.
Yes, we have exhibited that this is our sale deed, Lordship. Now, my second limb of argument
They
is
must have filed a certified copy.
nothing, they have not filed anything.
They came for cancellation of sale deed.
But they have not filed any sale deed, either certified copy or anything. They have not filed. Lordship, I'll show up all those things.
Firstly,
That
not
is
filed.
that cannot be denied by my friend.
Not filed sale deed
Even the certified copy
or
is not.
CC. Okay. So, did they say that it was a nullity?
Lordship, I'll just be placing the plaint also. No, Lordship, thereafter,
Do you want to say that the description of property in the sale deed is not matching with the plaint?
yes, Lordship. That is my argument.
Let us see.
Plaint हुजूर दिखाया जाता है.
प्लेन दिखाइए सेल डीड दिखाइए
हाँ, दोनों वही दिखा. Lordship got the plaint.
यस आप पेज में
Lordship. Schedule में Lordship.
शेड्यूल बी शेड्यूल ए
Schedule B, Lordship. That is the entire plot. Schedule A is the entire property of the plaintiff.
ओके
We are not concerned with this, Lordship. Now, Schedule B, Lordship. On one hand, Lordship, we keep this Schedule B, and on the other hand, Lordship, the description in the same.
You see, Schedule B has the area given, correct? Jamabandi number given,
Lordship.
Devghar, subdivision, Mauza given.
Lordship.
Now 6 through this much, together with 4 rooms specifically,
Lordship.
and the boundary
Lordship.
north, south, land.
Therefore, Lordship, I wanted to, Lordship, to have this sale deed which is Exhibit B.
is the vendor of this?
The plaintiff, Lordship.
Plaintiff is the vendor of this.
Plaintiff is the vendor, has sold to the defendant, and they both are own sisters. It has come in the deposition, Lordship.
Let us see the description of property in the sale.
In the sale deed, Lordship. Lordship got that. ऊपर से देखा है?
The map is also there.
Lordship.
Map is also there.
Map in the sale deed. Yes, yes. That is my sale deed, which we have. In
Yes, yes. We are looking at that only.
Yes, yes. Sale deed map is there, Lordship.
Yes. Now the boundary is mentioned. Is
Yes.
it matching?
Boundary is not matching at all,
Wide common road.
except south.
Just a moment. Wide common road. Orchard land to the south.
फर्स्ट Lordship उत्तर देखा या नॉर्थ?
North.
नॉर्थ मुझे सेल डीड में है केवाला दाता गण की जमीन के मकान, एंड हियर नॉर्थ इज रोड.
नहीं, ये तो कौन सा आप देख रहे हैं? तो ये एक साइड दिख रहा है.
अच्छा मैप
मैप देखिए.
ठीक है ना, वही तो
ठीक है?
मैप इज माय बाउंड्री एंड मैप आर सेम. हम बाउंड्री से पढ़ रहे थे, तो यहाँ बाउंड्री लिखा हुआ है.
हाँ, ठीक.
हाँ,
यहाँ.
केवाला
से
दाता
लिखा
गण
है.
की जमीन. Lordship got that. And here the north is road. North portion is not matching. South is matching.
South is matching.
Gochar land. Now, Lordship, the
Yes.
east पूरा
नहीं,
बनारसी लाल गुप्ता की चार दीवारी,
that is not matching.
and land is of Rajiv Shah. Thereafter west also not matching. Common
West is
road,
also.
और इसमें हुजूर है इसमें land of Jamuna.
Three boundaries are not matching.
Yes, that is major thing, Lordship, for identifying the suit.
Area
Area is matching.
is matching.
1 कट्ठा 6, 1 कट्ठा 6. Plot number is not there. Now ward number is not there, and holding number is not.
उनको भी प्रोवाइड कर दीजिए. प्रोवाइड कर दीजिए. उनको दे दीजिए. हमको तो पता ही है नहीं. आप देख लीजिए यही ऑर्डर. Both the sides please have a look
Yes,
at
yes.
this.
वही वाला. Now, Lordship, on this regard, I will give you 2-3 judgments, Lordship.
No, we'll come to the judgment later. Just a moment.
Lordship.
Yes, respondent.
Yes.
कैसे आप इसको मीट करिएगा?
And one more thing, Lordship.
अब जजमेंट बाद में पहले.
नहीं, judgment पे नहीं आ रहे हैं. In the plaint, Lordship, they have also not attached any map.
No,
Three
may not be.
conditions are there.
कोई बात नहीं. सेल
Anyone
नंबर
could
है
have
ना?
been. हाँ, ठीक.
सेल डीड नंबर है ना?
हाँ, सेल डीड.
हाँ, आप उनको ये बताइए आपने सेल डीड क्यों नहीं प्रोड्यूस किया?
That is not a question that has been framed by me.
नहीं, I just want to
Yes.
know. You never produce a
Because my suit was that I had not executed any sale deed whatsoever. So if this was my plea, and
It was by impersonation.
This was my plea that I had not executed any sale deed, and along with the plaintiff, who was the mother, there was all other were minor at the time when they said that the sale deed was executed. So both the courts below, they came to a very specific finding that on the date when it was executed, the property belonging to minor could not have been transferred even otherwise. So therefore, if the property belonged to the original owner, he died leaving behind his wife and other sons or daughters who were minors, then she did not have the right, absolute right to transfer on behalf of other minors also. And that is again
Being
the
a
provisions
guardian,
of,
she could not have done it.
because under section 8 of Minority and Guardianship Act, there is absolutely specific
That's right. That is required.
yes, that is required, that and that That
Even
section
for
itself says,
even for legal necessities, it is required.
no. What is that section?
Hindi
Without-
minority and guardianship.
Without reading that, we
You
must-
just tell us. I just
Yes.
don't remember the exact content
Yes.
of that.
But the permission of the court is required. And in that permission, then the court would see as to whether legal necessity is there or not. Without permission, absolutely the whatever transfer
So
is
your
made,
contention is whatever be the boundary, whatever be the discrepancy in the description of the property.
this is one. This is one. Yes.
Since it is not in dispute that as per them also and as per you also, vendor is the same.
Vendor is same and they were minors. This is also undisputed.
This is also undisputed. So therefore,
Except the mother. That means the plaintiff, original plaintiff number one, she could not have been said to be a minor. All the children, all other plaintiffs, they were minor, and this is undisputed. And this is the finding of both the courts.
in case any sale deed is executed in violation of section 8 of the Hindu Minority and Guardianship Act, what is the remedy for the minor?
Yes, minors, they may, after attaining majority, they may disown the transfer.
And if they don't,
And then they have
becomes
consented. Absolutely.
so here there is no story of disowning.
Here, when we file a suit, and when we file a suit saying that we have not executed any sale deed, and
You
my
have
mother
not
had not,
executed means
that-
the mother has said that is there any finding that she did not go to the registry office for execution of the sale deed?
no,
So therefore there is no such finding.
no such finding, but
She has executed the sale deed for herself and on behalf of the minors. So far as the minors is concerned, it was in violation of Hindu Minority and Guardianship Act. By the time the suit was filed, by the time the suit was filed, those children had attained majority or they had not attained majority.
they had.
They did not take any steps to disown this particular sale deed.
Once we filed the suit, saying that no, there was no sale deed, then we could not have taken another adverse plea that yes, it was executed and then we are disowning. So if this was the
So
stand,
your objection that they were minor does not stand anymore. Your objection is that she did not execute.
she did not execute, and even if she had executed, then also obviously after attaining majority they were challenging.
No.
They were challenging. They could not have taken
Is
a
there? It was not their case that she had executed, and even if she had executed, it is not binding on us.
Now, Your Lordship,
Who
this
is the
could not have
plaintiff in
been.
this case?
This could not have been. This would have been contradictory plea by the
Very well, they
minors.
could have filed another suit. We do not know.
By the minors, it could have been a contradictory plea, because if they would have said that
See,
because they were challenging the entire
today
execution
only I
itself.
have pronounced a judgment. Abhi, just now. When there is a case of impersonation and impersonation stands proved, फिर बाकी कहानी उस एलिट को कोई भी उसको validate नहीं कर सकता. Similarly, if there is a case that she never visited the registry office for the purposes of execution of deed, or maybe that there was no consideration, or there may be many instances of illegality in a sale deed, कि पता चले कि कुछ और करने गए, कुछ और करा दिए, इस तरह की बहुत तरह की चीजें प्रूव हो सकती हैं, right?
Yes.
But if there is no such finding to that effect, then under such circumstances, firstly, the deed is at least binding on the lady. First. Second, so far as the other minors are concerned, it is not their case that even if my mother had executed the sale deed, it is not binding on us. That alternative plea was certainly available to them.
Your Lordship, if the execution itself was being denied, execution and transfer itself was being denied, then impliedly it contained
What is
also
the
a plea
finding
that
of the court? Execution is admitted or not admitted ultimately. What is the finding of the court on this point?
that finding.
You have not filed any cross appeal or cross objection to this.
Because
Whatever
I'm
finding
not
has been
required.
done.
I'm not required. Because why I say? There is a Supreme Court judgment very clear on this point, that if ultimately the suit is dismissed, let us assume dismissed, in this court, in this case it was decreed. Now if the suit itself was ultimately decreed, then there is nothing, I cannot file an appeal against only a mere finding. Even if some finding is there, then what I can do, then when an appeal is filed by the other side, then I can show before the appellate court that that finding is wrong. That is all. I can support still the final conclusion of the trial court. I can support that the ultimate dismissal of the suit or ultimate decree of the suit by the trial court was proper.
Are you not supposed to file any cross objection to this?
No.
If there is a material
because
finding.
this question has now come up, I'll show that. Your Lordship may only allow me.
Now let us see where
Because
we stand.
why?
Let us
Your
see
Lord-
where we stand. First thing is that you want to challenge whatever be the finding on that. We are on substantial question of law. This is not a regular first appeal.
Yes, absolutely.
We will confine ourselves to whatever questions
Yes,
of law
yes.
have been framed. There is no such question of law framed as to whether the finding of the learned courts with regard to the very execution of the deed is correct. That is not the substantial question of
Now,
law.
what is the substantial question of law? Your Lordship may see.
Yes.
1, 2, 3 are read.
I have given you the copy of the order, a copy. A copy order. ये कॉपी देखिए order.
It is there.
First was, because your Lordship has quoted the earlier also and the subsequent. First is whether the learned trial court as well as the appellate court has misinterpreted the document of title Exhibit B, say B, so and so, which is a registered document and has a presumption that it is validly executed document, and as such, onus is on the person who alleges the contrary. Now, here it was a case where I had said that our case was that it was not executed at all by us, and there was no transfer by the original plaintiff or the plaintiff. There was no transfer whatsoever. So once this denial was there that there was no transfer, then it was for the person who was relying on the document to have proved that there was a valid execution, and the original plaintiff or plaintiff number 1, she had gone to the.
When you say that there was no transfer, when you say that there was that you did not execute the sale deed, that is a registered sale deed, then under such circumstances, at least the onus still does not shift to the other side. Because you have to show that under what circumstances it is not your case that it's a forged signature. It is not
No,
a case
because-
of impersonation. Then you have to show that under what circumstances this particular signature was appearing. You are the
Because
vendor.
my signature has not been proved.
Signature.
I say that I have not even gone, I have not executed, I have not transferred. So once I say I deny the fact, complete denial, then it was for them to have proved. This is
In
my.
connection with registered sale deed, there is a presumption. There is a presumption under law that it has been validly executed. And once you say that it has not been validly executed, you have to say under what circumstances it is not validly executed. You have to say in your plaint that this is not my signature. Unless you simply say that it is not validly executed, the onus will shift upon the purchaser.
Because there was entire denial of the
entire denial, ऐसा कोई
itself.
denial का कोई मतलब नहीं.
Execution itself. When the execution itself was being denied,
कौन
then
सा आप ही रोज बहस करते हैं बताइए कौन सा provision है about presumption. You see there is a presumption at least in connection with the, and on top of this anyways that you did not produce the sale deed also, the registered sale deed also. There is a presumption under law that whenever there is a registration तब तो सारा sanctity खत्म हो जाएगा. सारे registered आप ऐसा law मत declare कराइए कि आप आगे बहुत मुसीबत में पड़ जाइए. देखिए Mr. Rahul, we trust those practitioners who are hardcore civil practitioners because they are conscious of the fact that the second appellate court is pronouncing a judgment on substantial question of law which will bind at least the entire state. आप उससे निकल नहीं पाइएगा बाद में unless you get that finding set aside. that answer to the ये कोई रीड jurisdiction नहीं है कि discretion exercise कर दिए, एक में करेंगे दूसरे में नहीं करेंगे. अगर हम यहाँ पे होल्ड कर देंगे कि mere by stating that I have not executed the sale deed is enough, तो बस आपका जितना भी सेल डीड आएगा ना रजिस्टर्ड, यही आपको यही वाला जजमेंट लगाएंगे, यही यूज करेंगे आपके अगेंस्ट. ऐसा नहीं करिए. देखिए सब्सटेंशियल क्वेश्चन ऑफ लॉ में यू हैव मोर रिस्पॉन्सिबिलिटी एंड कोर्ट हैज ऑल द मोर रिस्पॉन्सिबिलिटी. लिटिगेंट से मत बताइए.
There was an alternative argument to this also, that even assuming that there was a sale deed by the mother, that means plaintiff number one, this would not have would have a binding effect on the others who are minors and who said by filing a suit that the sale deed was.
I want to know what was their age at the time when they filed the suit.
They say that for the first time they came to know about a sale deed when they were dispossessed by the defendants. For the first time they came to know that the defendants were claiming on the basis of a purported registered deed of the year 1992, and this is the date when we further inquired. They came to know that they were claiming that a sale deed had been executed by the mother and showing other plaintiffs also as offenders. This was the ground for filing a suit, and in this there was a complete denial to the transfer itself, and to obviously that denial included they could not have subsequently and taken a contradictory plea that they were not bound by the transfer made by the mother, because the entire transfer itself was now denied under cloud. And if the defendants, they were relying on that, then they could have said that yes, at least the plaintiff number one, she was bound by, we ought to have got the share which was there, although the others were minor, and although their share could not have been transferred, but at least it was binding on the mother itself. So there was no such plea. Now here is a case that the deed itself is absolutely by the mother.
Let us have a look at the plaint.
Yes.
Let us have a look at the plaint as to what was your case before the trial.
Only para 12 lordship is required.
हम only para 12 तो नहीं पढ़ेंगे
हाँ
ना?
पूरा पढ़ेंगे. Para 12 में specific है उनका, that is without consideration.
Without consideration भी है.
हाँ.
And no permission taken भी है.
नहीं वो नहीं.
वो है ही नहीं.
वो नहीं, वो that is beyond whatever their argument lordship, that is beyond me. Alternative argument in a plaint cannot be sustained. If lordship at all, the minors would have come.
Yes.
Saying that minors could have filed a suit saying that whatever deed registered by my mother is not binding upon us because that is voidable under section 8 of the State Act. That is not the pleading.
They did not seek a declaration
Yes.
that it is voidable because
Yes,
of this
not at
reason.
all. Nothing is there.
पढ़िए plaint.
Yes. I'll read for entire or if you
नहीं
want
नहीं
to
खोलिए
say.
आपका relevant portion पढ़िए.
Yes. Para
जहाँ minority की बात
para 9 onwards.
एज की बात की है. पैरा 9, पैरा 4 पढ़िए. पैरा 4 पढ़िए तो.
That accordingly, Chiman Ramani died leaving behind his widow Chini Devi and 3 sons named Ram Ravani, Vinod Ravani and Ganesh Ravani, and accordingly they had inherited the entire 2 kattas, 15 dhurs together with building etc. That the detailed description of 2 kattas, 15 dhurs that together with the building has been mentioned in Schedule A of the plaint. That subsequently he said Chini Devi had remarried with her devar, that is husband brother Chedi Ravani, and Chini Devi along with her children and the second husband Chedi Ravani are residing in Schedule A property. That thereafter, except the residential building, Chiman Ravani had further constructed 4 rooms without roof. Some portion of the rooms of roof is made of asbestos, and some portion of the rooms they are residing by putting plastic over the roof. That thereafter, unfortunately, Chiman Ramani died due to lack of money, and due to lack of money, they failed to complete the RCC slab over the 4 rooms. That very recently, on 4/2/2003, when the plaintiff number 1 and other male members were present in Schedule A property and were not present in Schedule A property, and after taking advantage of the absence of plaintiff and defendants, along with some antisocial element, started assaulting other family members of the plaintiff, and they have illegally trespassed in a portion of the building of the plaintiff, resulting with the plaintiff number 1 has filed a PCR before SDGM Madhupur, right, so and so, and the same is pending there. That except the PCR 144 proceeding was initiated by the plaintiff.
Not even a word that they were minor. Not even a word. You see, recitals in the sale deed are required to be proved. Execution of the sale deed का situation दूसरा है, उसका appreciation दूसरा है. But if in a recital of the sale deed somebody says that such and such is minor, that will not bind the parties. एक शब्द नहीं है कि आपका minor है.
तो minor था, but it was
हाँ, मतलब-
undisputed fact before the
And
court.
how do you undisputed? आपके plaint में नहीं है कि जब हम minor थे, then
Yeah.
under such circumstances, how do you say it is undisputed? And if it was there in the plaint, then you have to prove it.
And there
That-
could have been a rebuttal also.
There could have been a rebuttal also. कोई अगर माँ बोले कि नहीं मेरा बच्चा तो है 20 साल का लेकिन हम लिख देते हैं minor है और sale deed execute कर सकते, possible?
But entire evidence and pleadings were confined
Not
to
beyond
the
the
fact
plaint. Not
that-
beyond.
that-
आप कहानी कुछ भी अपना एविडेंस में लेके आइए, बियॉन्ड द प्लेन तो हम नहीं सुनेंगे. कुछ लॉ बताइए, तो हम सुनेंगे आपका बियॉन्ड द प्लेन.
इसमें है कि
एक शब्द नहीं है, पूरा पढ़ लिया आपका प्लेन, दिखाइए. एक शब्द नहीं है,
हम माइनर का बात नहीं लिखे हैं.
है ही नहीं कहीं. फोर्स्ड, फैब्रिकेटेड, विदाउट कंसिडरेशन, इतना बात है. माइनर का कोई बात नहीं, इसलिए माइनॉरिटी की कहानी हम लोग नहीं सुन सकते.
And this was not even disputed by them that they were minors.
If there is
नहीं
not
नहीं,
a
कहाँ
plaint-
से डिस्प्यूट करेंगे? आपके प्लेंट में नहीं है तो रिटन स्टेटमेंट में इसका डिस्प्यूट कहाँ से है? You can't improve the plaint, isn't it? Show me a word from the plaint.
है मतलब
दिखाइए.
entire pleading has to be seen, and in
नहीं.
isolation it cannot be seen. That is my.
आप पढ़िए, कहाँ भाएगा? आप हमको एक माइनर दिखाइए ना कहीं पर. माइनर
That is not their case, Lordship. Therefore,
नहीं,
they
कोई
have
बात
not
नहीं, आप
been-
बैठिए ना, उनसे पूछ रहे हैं, आप क्यों परेशान हो? वो अपने
Case
परेशान.
नहीं है उनका, तो कहाँ से लिखेंगे?
नहीं.
लिखा हुआ था कहीं तो आया था.
आप पढ़िए, फिर से पूरा
Pleading
पढ़िए.
नहीं होगा.
Judgment में-
जजमेंट से थोड़े चलेगा,
Yes.
प्लेंट से चलेगा.
पैरा 6 में चिल्ड्रन लिखा हुआ है, मतलब
Children
वही
मतलब-
माइनर ही होगा.
चिल्ड्रन तो हम
Because,
लोग भी अभी तक माँ बाप के
after-
बच्चे हैं.
After 18 they would not be
नहीं,
referred to
नहीं.
as children.
देखिए, as long as parents are alive,
At the time of their Lordship might be children, but when the sale deed,
no, we are not bothered about.
when the plaint
Children
was
लिखने
filed,
से-
it is not that. The time of filing of the plaint, they have to-
As long as parents are alive, their children remain children. ऐसा ही concept.
So, Your Lordship, my basic plea is that because the entire denial was there, it covered everything, and it covered the denial to execute the sale deed also, and therefore it was for the defendants who were relying on a document to have proved that it was not only validly executed and they had been put in possession of the property on the basis of the sale deed executed by the.
They are
This
in
was-
possession, admittedly.
Now we have said that because they had dispossessed us from that particular Schedule B property, therefore,
When and how?
then that I have stated. That statement is there. On 4/2/2003, para 9. That is the date of disposition.
Is there any finding regarding date of disposition?
With regard to date of disposition.
Mutation हो गया था आपका? Mutation हो गया था?
Exhibited, all those things are exhibited.
Mutation is also there.
Yes. Exhibit D is rent receipt correction limitation. Holding tax is also there.
Holding
number is
tax mutation sub end.
also
2009 volume 5 SCC 713 applying.
there. No.
What is the kind of presumption in connection with the registered document?
Several judgments are there, all one by one on that. Paragraph 19 and 34. And 19 first question.
Just. तो ये जो ऑर्डर में ये दोनों क्वेश्चन ऑफ लॉ है, दिस शुड बी सफिशिएंट.
Yes.
ये वाला presumption regarding registered
Presumption and this
document
particular-
and this order 7 rule 3
Yes.
इससे हो जाएगा.
No, this is right.
और बाकी order 41 rule 31.
No, that is wrongly
जाए.
framed, not sure. उसका जरूरत नहीं. Because point of determination is there and they have decided on the point of determination.
ठीक.
Now coming to the second question, you may see the second question.
Yes.
That has been framed. Whether the entire plate is hit itself is hit by the provisions of Order 7, Rule 3 of CPC as particulars of Schedule D property does not correspond to sale deed dated so and so, Exhibit B executed in favor of the. Now your Lordship may see Exhibit Order 7, Rule 3. It does not even say so. So this interpretation cannot be there. Now, firstly, your Lordship may see Order 7, Rule 3, and then it only says requirement is that the property must be sufficiently identifiable. And if it was not corresponding to the sale deed, this was required to be specifically pleaded. This was a fact which was required to be pleaded. As on the first question, I was required to plead that particular fact. This was also required to be pleaded. That there was a difference, the property was not identifiable in term, therefore it is barred in terms of Order 7 Rule 3. Order 7 Rule 3 only says, I'll read out once again. That would not be covered by Order 7 Rule 3. Where the subject matter of suit is immovable property, where the subject matter of the suit is immovable property, the plain shall contain the description of the property sufficient to identify it, and in case such property can be identified by boundaries or numbers in a record or settlement of survey, the plain shall specify the boundary or number. It does not even speak about comparing the said boundary or others with the said.
And in case such property can be identified by boundaries or number numbers in a record of settlement or survey.
That is all. So if it was there in
This
Schedule
record
B,
of settlement or survey will not include the registered sale.
no, absolutely not. Now this your lordship can say that no, even if this order 7 rule 3 is taken off, is not considered, then also I was required to prove that it must match the property description, must match the sale deed and all those things. But this was required to be pleaded. If that original pleading is not there, how the parties would explain as to how there is a difference? Probably the other side of the, because one side is matching. Schedule B is a portion of Schedule A property. So once it is a portion of Schedule A property, then it is included, the Schedule B is included in Schedule A. So I would have an explanation, or I could have shown that why it was not matching with the sale deed. Now I have only come simply sitter, my prayer is that please declare I have not executed any sale deed, and that sale deed, even if any, is void. That is my sole plea that has been taken.
What is the nature of written statement?
Nature of
Written statement. What plea have you taken in your written statement?
from para 2 onwards. Para 1 of the print contains the genealogical description of the descendants of late Chimuramani, who is the former husband of the plaintiff number 1, who died leaving behind his 3 sons, namely such and such, who were minors at the time of death of Chiman, and plaintiff number 1 got herself remarried with Chedi Ravani, who was none but the brother of the late Chiman. That in para 2 of the print states the description of the land which late Chiman Ramani got it settled during the lifetime was fully admitted by the defendants, but the full description of the land is hereby detailed, which was settled in favor of the late Chiman Ramani, that is 4 kattha Basauri land, bearing survey plot number such and such, town number such and such. This here also, Lordship, we have given the survey plot number, everything, but it does not find place in the Schedule B of the print. Para
So
3
it
of
is
the
not a
print,
description of Schedule B.
Lordship. Para 3 of the print is also correct. The defendant admit that Chairman Ramani died during lifetime such and such. About one Jamna Devi was registered sale deed, dated such and such, still alive. And this Jamna Devi's lordship was one of the attesting witness of my sale deed. Para 4 of the print is also true and the correct. Therefore, the defendant admit that after the death of Chiman Ramani, his wife Jini Devi, 3 sons, namely such and such, such and such, such and such, inherited 2 katthas, 15 dur of lands out of 4 kattha land stated above, but the 3 sons mentioned above were minors at the time of death of their father Chiman Ramani. Para 5 of the print is the description of the Schedule A property contained 2 katthas 15 durs, but of the said land the plaintiff number 1, namely Jini Ravani, who is the wife of Chiman Ramani, since this is transferred 1 kattha 6 durs of land in favor of Parvati Devi, defendant number 1, by dint of registered sale deed such and such, and her minor sons, namely Ram Ravani, Vinod Ravani, and Ganesh Ravani, has also contested, and their names are fully mentioned in the aforesaid sale deed executed on 15/12/1992. Since the sub-registrar Devkat Jini Devi left behind the legal guardian, the head of the family executed the aforesaid sale deed. On the other hand, Bhagwati Devi paid the consideration amount to Jini Devi in execution of transfer of the sale deed detailed below. Land measuring 1 kattha 6 durs under part of plot number 1065. We have mentioned here, plot number is not there, under Thoka number, Javandi number such and such, Halka, Madhupur, within ward number 1115. Ward number is also not there, of Devgarh municipality. That part of the, and this lordship plot number 1065 is a survey plot number. It is required to be mentioned as per order 7 rule 3 also. The part of para 6 is true, but other part regarding the residing of the plaintiff in Schedule A is false, because after the execution of the sale deed as mentioned in para 6, the plaintiffs have with them only such and such land. The contents made in para 7 of the print is not true, rather misrepresentation and concealment of the fact, because Chiman Ramani never made any construction over the land in question, rather defendant number 1 along with other defendants are coming in legal and actual physical possession of the land in the question mentioned in the Schedule B of the pen. Paragraph 8 of the pen is totally false and bogus as well as concealment of the fact, because defendant number 1 has made construction over the Schedule B of the pen due to lack of money, and the defendant number 1 could not make complete proof of some portion of the house. It is false and fabricated, the PCR case number brought by the plaintiff number 1 only with the oblique motive of putting pressure upon the defendant number 1 and other defendants to give up their right, title and possession over the land in question mentioned in Schedule B of the pen, which the plaintiff number 1 has herself along with the defendants transferred land by virtue of the sale deed mentioned in the preceding para of this pen, and the plaintiffs are again claiming over the land which they had transferred by a legal indenture before the rightful authority, which is definitely not permissible in the law. The proceedings 144 CRPC was initiated against both the parties from the court of the learned SDM Madhupur on the basis of the false complaint made by the
in your
plaintiff.
written statement, apparently you have not taken a plea that the description of the property in the sale deed is not matching
Lordship,
with the description of the property over here. There is a latest excuse.
yes, only on that point, Lordship. Since Lordship, they have come to the court to get a finding in their favor. Relief they have claimed. It is upon them to prove. They have to stand on their own legs. But see, this is my description of the property, and this is the sale deed, and which we have
Do you want
produced
to
before
say,
the court.
Do you want to say?
Now, yes.
Do you want to say, if there is a description of property in a sale deed, that description will continue to be the same for all times to come?
Yes. In this
Yes.
case, at least in this case, Lordship.
देखिए, case
Not
wise
all
nature,
times to come. Yes, yes.
right? The boundaries may change.
Yes.
पता चले कि पड़ोस में कोई और ले
अब
गया.
इसलिए उधर हम बता
Just
रहे
a
हैं.
moment.
Yes, Lordship.
पता चले पड़ोस में कोई और ले
और आ
गया,
गया बिल्कुल.
या कुछ एक्वायर हो गया,
बिल्कुल.
या रोड बन गया,
ठीक.
right? The boundary of a property may change from time to time.
Now,
Right.
yes.
Therefore, if a person says that the description of the property is not matching, then that has to be pleaded. This is what he wants to say.
Yes, yes. This is
Then
what he
it
wants
has to be
say.
pleaded,
But
and then the plaintiff would be in a position to say that the description is not matching because of this reason.
yes, very correct.
Right?
Lordship.
And further, so far as the identity of the property is concerned, that was not in dispute in your written statement.
Yes.
So you never disputed the identity of the property. So therefore, under such circumstances, your plea that the description of the property is not
Now,
matching,
Lordship.
not matching.
Yes. Only
To what extent will
2
it
lines,
stand?
Lordship, I'll be submitting. In the facts or circumstances of this case, this is a 5 rooms house. 2 rooms inside the house is in my occupation. Therefore, in this case, Lordship, the boundaries have not changed. It
So
is
we do
not their
not-
plea.
We do not know. We are just looking at the plaint and the
Yes,
written
yes.
statement.
We
We are not there on the spot to, we are
No,
not
Lordship,
surveying the
that
property.
has come in their own deposition. If this is the house, 3 rooms is occupied by the plaintiff, and 2 rooms after the sale deed has been occupied by the real own sister, and that is the dispute. Now they have not come with a pleading that it is somewhere else. सूट कुरान कहीं बाहर है, एक बाउंड्री बना के आपको दे दी है, वहां पे आपने घर बना लिया. That could have been a thing, Lordship, in another case. But in the facts and circumstances of this case, it is a very complicated thing. घर के अंदर ही 2 रूम इनको
If the
मिला.
boundaries are not disputed,
Yes.
then how your plea that the boundary mentioned in the sale deed is not matching
Lordship.
would be a crucial issue
No,
to
no,
decide.
Lordship. What I am submitting, boundaries in the sale deed is not matching with the boundary of the plaint. Since, Lordship, when the execution will go, suppose, Lordship, they get a degree in their favor. At the time of execution, that is what Order 20 Rule 9 is. If it is not executable because of the discrepancy on the boundary, it will have no food will be given to them. That is the judgment, Lordship, that I wanted to say.
Merely because a decree is not executable.
Yes.
Can it
Yes,
be a
Lordship.
ground to set aside
Yes,
the
yes, the
judgment?
court will be Lordship
That is not the point of law.
but Lordship is because of that, Lordship, the identification.
When you question the boundary of a property, which is not a static thing for all times, therefore under such circumstances there has to be a plea in your written statement that the boundary is not matching, so that they also get a chance to explain as to why the boundary is not matching. Right? There is no such plea. Therefore, as you say that there is no such plea, they were minor. There is no such plea that the boundary is not matching. Therefore, under such circumstances, merely by referring to the sale deed, it is not a pure question of law. That by saying, by looking at the sale deed, it is a equator hai kya? South में equator है. It is not going to change for all times.
इस केस में क्या है, घर के अंदर की बात है.
नहीं ऐसा
तीन
नहीं
रूम मिला है,
केस
दो
टू
रूम
केस
हमारे
बेसिस पर हम लोग पॉइंट ऑफ लॉ नहीं डिसाइड करते. हम लोग प्लेन रिटन स्टेटमेंट में देखेंगे
हाँ,
कि आपका क्या प्ली
एग्जैक्ट रीडिंग ऑन
माइनॉरिटी का इनका कहानी तो हम सुनने नहीं वाले, जबकि आपने रिटन स्टेटमेंट में सब लिखा है कि वो माइनर है.
जो नहीं लिखना चाहिए.
हम नहीं जानते आपको लिखना, आपने सच्चाई लिखी है. I will not say कि क्या लिखना चाहिए था, but you have written it in your written statement, right? But that is not their plea. That it is not binding.
Pleading is not.
एज भी नहीं है कि भाई अब हम 3 साल से ये मेरा एज हो गया है, इट इज विद इन 3 years और आई वांट टू अवॉइड इट. कोई अल्टरनेटिव
इसमें लिखा है at the time of death of the father they were minors and thereafter the mother married to the payer. That has come. But regarding this lordship, if lordship is of opinion that since the sale deed the pleading should have been there, the pleading is not.
अच्छा मान लीजिए अगर सेल डीड मैचिंग नहीं भी है,
हाँ.
have they been able to prove that there was any impersonation or there
No,
was
no,
no
not
consideration?
at all. What?
ये सब तो भी इससे क्या ही फर्क पड़ेगा? आप बताइए आपको क्या फर्क
नहीं,
पड़ेगा?
हमको कोई फर्क नहीं.
आपको कोई फर्क नहीं पड़ेगा. Because they have not been able
Yes,
to
yes,
prove that on account
And the
of
presumption
these
is
very
in my
reasons.
favor, yes.
And if the first question of law is decided in your
Yes, कोई
favor,
फर्क नहीं पड़ेगा.
कोई फर्क नहीं पड़ेगा आपको इससे.
Either of them would.
Either of them will survive your purpose.
Yes.
And they have to meet both of them.
Yes.
अभी सेकेंड वाला का हम कंप्लीट कर देते हैं. सेकेंड वाला, your lordship, another argument is with regard to order 723 is that in our plaint we have said that schedule B is a part of schedule A. So schedule B cannot be seen in isolation. It has to be taken with schedule A, which complete description is there, and then schedule B has to be taken with whether it was proper. And this plea was not there. And schedule A complete description is there with, and all these were matters of trial which were required to be there. Unless and until there was pleading, this could not have been tried by the trial. Second,
And actually not tried also.
not tried.
Not tried.
Not tried because
This plea has been raised for the first time in the second appeal.
yes, absolutely.
Yes. This is because since
This plea was not there in the first appeal.
no, because it is a point of law, lordship. There is
It is not a point of law.
description of land.
This
subject
point
matter.
of
boundary
law-
of a property is not a point of law.
Point of law based on facts. Yes, unless and until
The
they
pleading
were
and counter pleading,
Yes,
yes.
absolutely. And with regard to the first one, last submission is that I could not have proved a negative. I could not have said that no. I could have only said that I had not executed. I could not have proved that I did not go to the registry office. I did not go to the registry office on so and so, and then I did not execute any sale deed on so and so. I could have only said that I had not executed any sale. That is all. This is all, Your Lordship. I'll not waste Your Lordship's time. My submission is, as Your Lordship pointed out, that there is an admission in the WS itself that they were minors.
One more judgment on point of the presumption, lordship. Para 2720. I have indicated the paragraphs, lordship. In this case, lordship, paragraph 38.
आपका कंटूर्स ऑफ आर्गुमेंट लिखा लेते हैं, लेकिन एक छोटा नोट जरूर.
ठीक है.
ठीक है, कंटूर्स हम लिखा लेते
ठीक है.
for this substantial question of law जो पहले order 41/31 का था इसको give up करवा दें?
हाँ, absolutely general. Absolutely
that is general.
Very. This roving inquiry
With
cannot
respect
be
to
made
Honorable
in
Court Lordship, you are not even that that was not my substantial question of law, but that was framed.
very fair.
आप
हाँ,
ऐसा नहीं बोलिए.
With
आपके-
respect, I already said.
आपके आपको सुन के
हम
clear है
एक
ना?
के लिए काफी है।
अगर कोई कोर्ट बोल रहा है कि ये सब्सटेंशियल क्वेश्चन ऑफ लॉ है और ये नहीं है तो आपका भी ड्यूटी है बोलने का कि ये नहीं है राइस ऐसा कोर्ट को नहीं बोल
Lordship was
सकते
fair
वो भी
enough
दूसरे
to-
कोर्ट के पास
Add those.
हमको बोलते मेरे
हाँ.
पास तो ठीक था.
Though two other
Yes,
substantial
yes.
questions, that is sufficient for me. I am only confining.
Yes. देखिए essay number 37 of 2021. Wide order dated 6 and heard the learned counsel for the parties. वो फाउंडेशन दे देंगे कौन सा अराइज करता है ये लिखा दें. This second appeal has been filed against the judgment and decree dated 31/2021 passed by learned district judge Roman 7 Devkar dismissing the civil appeal number 28 of 2019 and affirming the judgment and decree dated 29/3/2019 passed by learned civil judge within bracket senior division number 1 bracket close Devkar decreeing title within bracket D क्या होता है? D title within bracket D.
Lordship, reading where?
हाँ आपका मेमो ऑफ अपील है. टाइटल within bracket D क्यों?
वही नंबर दिखा दिया जाना because it is everywhere in the judgment also and trial court judgment and everywhere D has been written.
Title within bracket D.
Probably relating to declaration.
हाँ. Within bracket D
something.
bracket 2 suit number 16 of 2004.
Can I take your lordship?
हाँ
leave?
yes yes. आप कितना दिन में दे देंगे अपना शॉर्ट नोट? 2 दिन में दे देंगे ना प्लीज.
हाँ,
है ना?
ज़्यादा नहीं एक पेज.
हाँ एक पेज 1 पेज शुड बी सफिशिएंट. आपने ट्रायल कोर्ट का जजमेंट कहाँ लगाया है?
उसमें मुझे लगता है बाद में मुझे फाइट हुआ था.
देखिए तो इसमें बाद में फाइल हुआ होगा ट्रायल कोर्ट का जजमेंट. रिकॉर्ड पर होगा. देखिए.
Lordship, this is not in dispute. Therefore, your lordship can take this one also. Photocopy.
एक बार दे दीजिए. ठीक. This appeal was admitted by order dated 6/11/2023 on the following substantial question of law. However, wide order dated 27/2/2025 the following further substantial questions of law have also been framed. टोटल 4 हो गया. ठीक है. The learned counsel for the appellant has submitted that so far as substantial question of law as framed by the order dated 6/11/2023 is concerned, the first substantial question of law therein is essentially for the purposes of substantial question of law mentioned in paragraph 4 within bracket Roman 1 of order dated 27/2/2025, and therefore the first substantial question of law as framed by the order dated 6/11/2023 need not be separately answered. The learned counsel, he has further submitted that so far as the second substantial question of law framed by the order dated 6/11/2023 is concerned, the learned appellate court, upon reading of the appellate court's judgment, the point of determination were framed by the learned appellate court by paragraph 8, and the same was answered, and therefore he does not want to harp upon substantial question of law number 1 within bracket 2 of the order dated 6/11/2023. He submits that essentially this appeal be decided on the substantial question of law framed by paragraph 4 within bracket 1 and within bracket 2 in order dated 27/2/2025. The learned counsel for the respondents has no objection to the submissions made by the learned counsel for the appellant. Accordingly, this appeal would answer only the substantial question of law framed by the order dated 27/2/2025, paragraph 4, 1 and paragraph 4. The learned counsel appearing on behalf ने उसके बाद लिखे substantial question of law number Roman 2, number 4 within bracket Roman 2 of order dated 27/2/2025. The learned counsel for the appellant, by referring to the plaint, has submitted that the plaint had two schedules, Schedule A and Schedule B, and the suit was filed for a declaration and cancellation of the sale deed dated, for a declaration that the sale deed number 3043 dated 15/12/1992 is void and be cancelled, and the sale deed was said to be in connection with Schedule B property. However, the description of property and the boundary, खाली boundary है ना. However, the boundary of the property in the sale deed did not match.
The entire description also. Plot number is not there.
Plot number तो है 1074.
B में नहीं, schedule B में नहीं.
The learned counsel has also submitted that in Schedule B of the property, the plot number 1074 has not been mentioned. In Schedule B property, the municipal ward number 15 and part of plot number 1074.
75. As per said, that is 107.
1074 है उसका शेड्यूल में
वो उनका
Map
शेड्यूल
में?
गलत है.
मैप में भी गलत है.
हाँ, ये 1075 है सेट डेट.
नहीं, आपका ये जो बाउंड्री है इसमें
अच्छा, वो एक हाँ, इसमें 1074 है.
राइट.
अच्छा.
1074 as mentioned in the map to the sale deed is not matching. Is not mentioned in Schedule B of the the Learned Council has relied upon the provisions of Order 7 Rule 3 and Order 20 Rule 9 of CPC to submit that.
बहुत बड़ा डिस्क्रिपेंसी है. शेड्यूल ए में जो प्लॉट नंबर दिए हैं, which is the total area, entire land, वो 1455.
आपने तो इस सब कोई ऑब्जेक्शन ही नहीं दिया है. अब क्या पता
हाँ, नहीं, ठीक है.
नंबर होते रहता
हाँ,
है.
खाली जरूर बता.
अब वो तो है नहीं, अब हम क्या बोलें.
नहीं, चूंकि यहाँ पे लिखा है इसलिए अचानक अभी दिखा. That is plot number is there, but that is also not in corresponding to the sale deed. In schedule A also, which is the entire land of the plaintiff.
He has also submitted that. आप उनके absence में इस तरह से submission करेंगे तो कैसे ही क्या? He has also submitted that in the Schedule A, the plot number has been mentioned as 1455.
Note.
However, on the body of the sale deed, the plot number has been mentioned as 1075, which itself is not matching with the plot number mentioned in the map. Correct?
Yes.
The Learned Council has referred to Order 7 Rule 3 and Order 20 Rule 9 of CPC to submit that if the description of the property is not matching with that of the sale deed, then under such circumstances, the suit itself was hit by Order 7 Rule 3 of CPC and no decree could have been drawn, as such a decree would have been a non-executable.
Yes.
यही है?
Yes.
The कोई इस पे कोई judgment है?
हाँ, वही तो. So, paragraph. I'm just underlining the video. This case question, paragraph 5, it is 1996, volume 6.
Yes. He has relied upon the judgment passed by the Honorable Supreme Court 1996, volume 5, SCC 699. Para number is?
Para 5, Lordship, I have underlined the portion.
Para
In para 5.
5.
Lordship.
The Learned Council submits that on account of discrepancy in the description of property, the second substantial question of law is fit to be answered in favor of the appellant. He has also submitted that if the second substantial question of law is answered in favor of the appellant, there may not be any need to enter into the first substantial question of law. Correct?
Lordship.
However, with regard to the first substantial question of law, the Learned Council has submitted that the sale deed was a registered document and there is a presumption that it was validly executed and the onus was not discharged by the plaintiffs with regard to any discrepancy in the matter of execution of the sale deed. He has also submitted that the learned courts have given concurrent finding that the sale deed was validly executed. He has relied upon the judgments passed by the Honorable Supreme Court reported in bracket 2009, bracket close 5 SCC 713, para 19 and 34. To submit that once there is a registered document, there is a presumption that the transaction was genuine. He has also submitted that it has been held that as soon as the sale deed is registered, the title passes away to the vendee. एक जजमेंट काफी
एक और उसे पैरा 30 115
he has also relied upon the judgment passed by Honorable Supreme Court reported in
2006 volume 5 SCC
2006 volume 5 SCC
353
353
para 27 28. I have given that judgment also.
para 27
And 28.
and 28. Yes, he has also relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2006 bracket close 5 SCC 353 para 27 and 28. To submit that
will cover my lord's question.
Yes.
So,
to submit that if the vendor is a minor and it was void, he has two options to file suit to get the property conveyed thereunder. He can either file a suit within 12 years of the deed or within 3 years of attaining majority. And in the present case, the plaintiffs in the present case, the deed was executed by some of the plaintiffs who were minors, but they did not make any such option. He has also submitted that though in the plaint no such plea was taken that some of the plaintiffs were minor at the relevant point of time, but this fact has come up through the written statement. But the age of such minors have neither come up in the plaint nor in the written statement.
it has come not so that they were minor at the time of death of their father,
He has also submitted that in the
not
written
at the time of
statement,
execution.
it has come that that some of the plaintiffs were minor at the time of death
Of their father.
of their father, but nothing has come about their age
At
as
the time
on
of
the date
execution.
of execution of the deed. उनके पिताजी का डेट का डेट आया है.
नहीं वो भी नहीं.
He has submitted that it has or not come as to when the father had expired.
The husband of the
Plaintiff number 1.
हाँ,
Father/husband of the plaintiff number 1 had expired.
it has not come either in the plaint nor in the
Either in the plate or in the not in the written,
Yes.
written statement. The learned counsel has submitted that the plaintiff never raised a plea that the sale deed was void on account of the fact that the other plaintiffs other than the plaintiff number 1 were minor at the time of execution of sale deed.
Yes.
The learned counsel for the respondents, on the other hand, while responding to the substantial question of law number 2, has submitted that the defendant in the written statement never raised any objection with regard to identity of the property, nor they raised any objection that the description of the property as mentioned in the sale deed was not matching. He submits that the parties did not join issue with regard to identity of the property. Had such an issue been raised, then the plaintiff could have adduced evidence as to how the boundary was not met. The area was certainly matching. He has further submitted that since the parties did not join issue with regard to the identity of the property, there is no occasion to hold that the suit was barred by virtue of Order 7, Rule 3 of CPC. The learned counsel has also submitted that the Order 7, Rule 3 of CPC does not provide that the boundaries of the property are to be mentioned
As mentioned in the sale deed.
as mentioned in the sale deed. What is important is that the property should be identifiable. He has submitted that once the identity of the property is not in dispute, the second substantial question of law is fit to be answered in favor of the respondents. With regard to the first substantial question of law, the learned counsel has submitted that as per the written statement, the plaintiffs other than plaintiff number 1 were minor, and therefore, in absence of required permission from the court in terms of Section 8 of Hindu Adoption and Hindu Minority and Guardianship Act 1956, the sale deed was void, at least so far as the minors are concerned. The learned counsel has further submitted that once the plaintiff stated that she did not execute the sale deed, the onus was upon the defendants to prove that she had executed the sale deed. And this onus was not discharged by the defendants. And therefore, it cannot be said that the onus was that, and therefore, no adverse inference can be drawn against the plaintiff merely because the deed was registered. That's all. आपने कोई जजमेंट स्पेसिफिकली रिलाई किया है किसी पर? ऐसा तो कुछ नहीं. अच्छा, ये तो हो गया. Arguments concluded. The parties are directed to give short synopsis of arguments on the basis of arguments advanced in the open court. एक चीज़ और डिस्क्रिपेंसी उन्होंने बताई है. शेड्यूल ए में जो है आपका जो प्लॉट नंबर है, that is not matching with this deed.
Again, same reply.
नहीं, वो सेम चीज़. दूसरी बात, इनके सेल डीड में भी मिसमैच है. तो मेन बॉडी में जो है उसका मैचिंग नहीं है उस शेड्यूल से. इट इज़ नॉट मैचिंग. Basically, your argument is that discrepancy having not been pointed
Yes,
out, not taken,
pleaded, yes.
not pleaded. Therefore, there was no dispute regarding identity.
No, and the parties do not get an opportunity to
That's right.
explain as to.
That I have taken care. एक बात बताइए, in a case, this is over now. In a case where a person says that I have not executed the sale deed, तो handwriting expert के पास या expert witness ये सब के लिए किसका होना चाहिए?
The person who alleges.
Person who alleges.
But there is one judgment, 1985, our own Patna High Court, where there was a dispute between landlord and tenant. The landlord denied because tenant was relying on a rent receipt issued by the landlord. The landlord said that this did not contain
Where
my
in
signature.
that case, Lordship, presumption is not there. It is not a registered document.
Then it was said that it
अच्छा
was.
ठीक, बस इतना ही कहूँ. In response, the learned counsel for the appellant has submitted that there is a presumption in connection with registered sale deed,
For which Lordship have given.
and it was for the plaintiff to
Duty of the
prima
plaintiff.
facie rebut the presumption, and no steps were taken by the plaintiff to get the fingerprint. Fingerprint.
No, yes, finger. Handwriting expert or handwriting
हाँ,
slash
दोनों
To
fingerprint.
get the fingerprint or the
Admitted
signature
signature.
examined through handwriting expert or fingerprint expert. That's it.
Lordship.
इस पे भी अगर कोई एक judgment हो तो आप दे देंगे.
हम दे देंगे.
He submits that along with the written submissions. He shall furnish one copy of the judgment on the court. आपको भी अगर कुछ हो तो
ठीक, ठीक.
parties. हो गया, arguments concluded.
Yes.
हम डेट देंगे.
Lordship.
हो सकता है जल्दी ही करते क्योंकि
हाँ.
सुन ही लिया है पूरा.
बड़ा नहीं है बहुत है.
बहुत बड़ा
खाली
नहीं.
हुजूर को डिसाइड करना.
नहीं, लेकिन सेकेंड अपील में ना ऐसे ओपन कोर्ट में कोई चीज़ डिसाइड करने के पहले एक बार रिविजिट करना हर चीज़
That
को
is
जरूरी होता है. इसी वजह से नहीं पूरा डिक्टेशन देते हैं. सबमिशंस लिखा देते हैं तो आधा काम तो हो ही गया. फिर जो इम्प्यून जजमेंट्स है उसको भी एक बार थरोली देखना जरूरी है. आप लोगों ने तो प्लेस नहीं किया है,
हाँ.
थोड़ा फाइंडिंग्स इनको देखना.
Item 5, first appeal 46 of 2023.
It's a paying for second part.
Second half में some other matter is posted.
Also, arguing counsel will come at 1 o'clock. That's me.
कौन है आपके arguing counsel?
Mr. Anuj Kumar Trivedi. And also कल के लिए रख दिया जाए.
आपका तो केस अगला पिछला डेट में डिसमिस फॉर डिफॉल्ट कर देना चाहिए. पिछला डेट में भी आप नहीं आए थे, अभी आपको 1 बजे चाहिए.
Also,
कोर्ट आपके हिसाब से चलेगा क्या?
also पिछले डेट में एडवोकेट स्ट्राइक में.
तो बहुत अच्छी बात है. उस दिन स्ट्राइक में थे, आज एब्सेंट हैं.
No, lordship 1 बजे आ
ये
गए.
कोई रीजन है? आप स्ट्राइक पे रहिए. डिसमिस फॉर डिफॉल्ट नहीं हो सकता है केस. स्ट्राइक करना सब ठीक है. फिर
Kindly fix it.
नहीं नहीं ऐसा नहीं. अदर साइड कहाँ है इसका? नहीं हो सकता ना, सेकेंड हाफ में नहीं हो सकता.
लॉर्डशिप 1 बजे फिक्स कर दिया गया है.
मिस्टर नीरज राय इज देयर. आपका मैटर है, आप तो बहस करिए. ऐसे नहीं होता है ना. कांट बी लाइक दिस. आपके चॉइस से ना टाइम फिक्स हो सकता है, ना आपके चॉइस से इस तरह से डेट फिक्स हो सकता है.
लॉर्डशिप आर्ग्यूइंग काउंसिल विल कम एट 1 o'clock. दैट्स ऑल. 1 बजे फिक्स कर दिया जाएगा.
1 बजे से 1:30 बजे तक आप अपना फर्स्ट अपील का आर्गुमेंट कंक्लूड कर देंगे. यस, हो जाएगा कंक्लूड. फिर
लॉर्डशिप कल के लिए रख दिया जाएगा.
नहीं रखेंगे कल के लिए. कल के लिए रखेंगे, कॉस्ट इम्पोज करके रखेंगे, ऐसे नहीं हो सकता। स्ट्राइक में आप आइएगा नहीं, स्ट्राइक था इसमें, स्ट्राइक
लास्ट डेट 28th
स्ट्राइक
स्ट्राइक नहीं था वो बिकॉज ऑफ डेथ ऑफ
सुबह था वो बात की लेट सूरज कुमार को
तो ठीक है, हम एडजर्न कर दिए नॉन अपीयरेंस रिकॉर्ड करके। आज तो हम पास ओवर भी नहीं देंगे, उस दिन तो हम एडजर्न कर दिए थे आपका नॉन अपीयरेंस रिकॉर्ड करके। बताइए, चलिए जरा पढ़िए, ऐसा नहीं होगा।
ओनली वन केस लॉन्च
ठीक है, वन केस बुला के लेके आइए। वन केस बहुत तेजी से हो सकता है कभी कभी। चलिए कॉल करिए।
Orders be declared item 6 first appeal 66 of 2024.
Let us see back there for 3 weeks time.
आप डिफेक्ट देखें,
Yes.
3 मिनट नहीं लगेगा
ये
इसको
आइए
remove
फाइल
करने।
करना है।
क्या चीज़ में आइएगा?
Coordination of delay.
कॉन्ट्रीब्यूशन ऑफ डिले का तो कोई डिफेक्ट ही नहीं है।
Further stamp reporting में आया है.
FA number 66 of 2024, Learned Counsel for the appellant, praised for and is granted time till 24th of March 25 to remove the surviving defects plainly. If the defects are removed within time, post this case on 26th of March in the
Item 7 first appeal 134 of 2024.
Your Lordship, please come adjournment by 4 weeks.
as prayed, time till Fourth of April is granted to the appellant to remove the surviving defects plainly. If the defects are removed within time, close this case on 8th of April. ये सूरज कुमार कौन है?
He has demanded.
उनके अलावा किसी का वकालतनामा है? सूरज कुमार के अलावा तो किसी का वकालतनामा नहीं है। You are not supposed to. नोटिस करेंगे। ऐसा इसको फिर से लिखिए। MS नाम बताइए। Akanksha. Advocate submits that unfortunately the sole advocate on record, Mr. Suraj Kumar, has passed away. Office is directed to issue notice to the appellants through the concerned police station so that the appellants may take appropriate steps in the present appeal. Post this case on 26th of March. Password. कहाँ चले?
Password case item 5 first appeal 46 of 2023.
रिकॉर्ड
May it please Ladyship.
यस
The present appeal has been preferred against the judgment dated 13/12/2022 and decree dated 22/12/2022 passed by the Civil Judge Senior Division 2 Bokaro. This is the case of permissible occupancy and the suit has been filed for eviction of the permissible occupancy on the ground that the terms of agreement between the appellant and the OP has already been lapsed. The entire money which has been taken by the appellant from the defendant has already been paid. But that fact has not been considered.
व्हाट इज परमिसिबल ऑक्यूपेंसी आप फर्स्ट अपील बहस कर रहे हैं
Yes, that is.
रीट पिटीशन नहीं है
That is.
आपको पूरा बहस करना होगा प्लेन रिटन स्टेटमेंट एवरीथिंग
Yes, that is.
व्हाट वाज द सूट फॉर
For ejecting a licensee under permissive occupation. Suit has been filed for that reason.
प्लेस द प्लेट प्लेन पढ़िए
Copy of plaint is not there with me.
आप फर्स्ट अपील बहस कर रहे हैं ना कॉपी ऑफ प्लेट है
LCR I have not gone through.
एनसीआर नहीं है
Yes.
व्हाई हैव यू नॉट गॉन थ्रू
I don't have the copy. Today, an advocate from Patna has been engaged in this case to argue the matter.
So why have you started arguing? आधा घंटा बाद बोलेंगे अब पटना से बहस करेंगे
Because he could not come for that reason.
we will impose cost आज बिना कॉस्ट के आपको एडजस्टमेंट नहीं हो सकता
I put down the decision.
पिछली बार तो आप एप्लीट नहीं हुए
हम होना चाह रहे थे लेकिन पिछले डेट में आए भी थे वो पटना से लेकिन एडवोकेट एब्सटेन कर रहे थे लेडीशिप से.
आप लोग का एडवोकेट्स का सॉलिडारिटी में आप एब्सटेन किए थे तो आज आना चाहिए था ना
Yes,
आपका लेटर आया था मत कुछ एडवर्स ऑर्डर करिए जाने तो हम लोगों ने नहीं किया
85 years के वो थे इसी थोड़ा सा
कब रखना है बताइए
नेक्स्ट
बिना कॉस्ट के एडजस्टमेंट नहीं होगा लेकिन
कल रख दिया जाए ना हम तैयार कर लेते हैं.
आपको क्या लगता है मजाक है क्या फर्स्ट अपील मजाक नहीं है इतना स्टेट से आदमी का आपको इंस्ट्रक्शन मिला है क्लाइंट से
आज
समझ
सुबह
में
ही-
आता है फर्स्ट अपील
सुबह ही
ये है कभी फर्स्ट अपील आज तक एक लाइन बोल के चुप हो गए कि बस यही केस है रिट पिटीशन है रिटायरमेंट बेनिफिट डिस्पोजल ऑफ रिप्रेजेंटेशन का ऑर्डर चाहिए बताइए क्या है पॉइंट फॉर डिटर्मिनेशन यस बताइए व्हाट इज द पॉइंट फॉर डिटर्मिनेशन नहीं पता
सब्सटेंशियल क्वेश्चन ऑफ लॉ.
सब्सटेंशियल क्वेश्चन ऑफ लॉ फर्स्ट अपील में बनेगा आपका क्लाइंट आपको ये वीडियो देखेगा तो क्या सोचेगा आपके बारे में आप कभी इसके बारे में कभी विचार किए हैं आप कि फर्स्ट अपील में आप सब्सटेंशियल क्वेश्चन ऑफ लॉ की बात कर रहे हैं
Some other advocate were engaged in this case litigation for that reason.
therefore some cost has to be imposed
Tomorrow
आपके सीनियर कल आ रहे हैं जिस एडवोकेट को ये नहीं पता है अभी कि फर्स्ट अपील में सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं फ्रेम होता है पॉइंट फॉर डिटर्मिनेशन फ्रेम होता है आपके लिटिगेंट को आप कुआं में नहीं डाल सकते ना वी हैव टू लुक एट द लिटिगेंट आपके कहने से एक सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम करके इसको डिसाइड कर दें और अपनी भी बेइज्जती कराएं और आपकी भी बेइज्जती कराएं
point of determination.
कुछ नहीं पता है आपको
Leadership Amitesh Kumar Gesin was engaged in the morning itself.
आपको टाइम चाहिए कि नहीं चाहिए
चाहिए.
नहीं तो जो बहस करिएगा उसी पे हम डिसाइड करेंगे
It may be listed tomorrow.
हु विल हैव द केस
Amitesh Kumar Gesin.
आप किस लिए आए
He is
आर यू द
the-
एडवोकेट ऑन दैट
Yes. He's on bail. He's coming from his.
Learned counsel for the parties are present. On 22/2025, nobody had appeared on behalf of the parties. It has been submitted by the counsel and the matter was fixed for final disposal today. The learned counsel for the appellant has submitted that on that day, the advocates had abstained the court on account of demise of one advocate, and therefore he did not appear. Today also he is seeking time, and he submits that the matter will be posted tomorrow. However, no adjournment slip was circulated, and the counsel, and in order to give one more opportunity to the appellant to argue this case, the matter is. कल कितना केस है हम लोग का? कल ऑलरेडी 4 केस है.
Yeah.
The matter is directed to be posted tomorrow, subject to payment of cost of ₹10,000 to be paid by the appellant to the respondent. The receipt for क्या क्या कम करें इसमें? क्या कम करें हम इसमें?
पटना से आना था वो नहीं
तो आप बताइए पटना से किस दिन? अभी आप अमितेश कुमार ग्यासन की बात करते हैं, वो तो पटना से नहीं आता है. तो पटना से किनको आना था? इतना स्टेक्स है इस केस में. किनको आना था पटना से?
मिस्टर
नाम है कोई आपके
Yes.
सीनियर का? बताइए.
महेश प्रसाद.
तो आप बताइए कौन सा दिन रख दें? कॉस्ट तो कम नहीं होगा, दिन बताइए कौन सा रख, क्योंकि इतना स्टेक्स है इस केस में, हम इस तरह से नहीं कर सकते. बताइए कब आएंगे आपके पटना से?
नॉट वेल एट प्रेजेंट योर ऑनर.
तो आप बता दीजिए कोई भी डेट बताइए. छुट्टी के बाद रख देते हैं, बताइए. कोई दिक्कत नहीं, लेकिन कॉस्ट तो देना पड़ेगा. आप देखिए, आप इस चीज को समझिए. आपका इतना स्टेक्स, आप लिटिगेंट हैं, आप पार्टी है इसमें, तो कौन है आप?
He is also an advocate.
He is also. चलिए कोई बात नहीं. बताइए कौन सा दिन रख दे? छुट्टी के बाद 2 साल बाद बताइए, जो डेट बोलिएगा उस दिन रख दे, लेकिन बिना कॉस्ट के डेट नहीं. बताइए.
हार्ट का प्रॉब्लम
नहीं, आप बताइए ना भाई, कौन सा डेट रख दें?
कॉस्ट मेडिसिन.
कॉस्ट नहीं करते, कौन सा डेट रख दें आप बता दीजिए. नाइन्थ अप्रैल को रख दें. 8 अप्रैल. ये टुमारो वाला हटा दीजिए. He prays that the matter be posted on 8th of April. A counsel from Patna has been engaged to argue this case. Correct?
Yes, but he is not well, ladies and gentlemen.
But he is not well and therefore he has not come today. याद रखिएगा, अगर हम उनका देख लिए ना पटना में अपीयर होते हुए, I'll have all information from Patna on this. इस गलत फहमी में मत रहिए. नाम बताइए एडवोकेट जिसको आना है. हम खुद ही पता करेंगे.
महेश प्रसाद.
Mr. Mahesh Prasad, advocate from Patna.
The next date, some other lawyer will appear before. He could not come, ladies. He is suffering from heart disease.
He has also submitted that on the next day he will make alternative arrangement, as the counsel who was scheduled to argue this case is not well. Right? 8 तारीख को।
कॉस्ट थोड़ा सा
कॉस्ट कॉस्ट वी ट्रस्ट योर स्टेटमेंट। आपका क्या नाम?
अनुज कुमार त्रिवेदी।
भूलिएगा मत, अगर हमको पता चल गया ना कि वो बीमार नहीं है तो क्लास हम आपकी लगाएंगे बहुत जबरदस्त।
For hearing under order 41 rule 11 item 15 second appeal 25 of 2023.
Appealant,
Yes. In this case, the petitioner is this second appeal has been preferred against the order judgment and decree passed in civil appeal number 23 of 2018. The issue involving this matter is my lord, the petitioner has.
who are you? You are the
I am the
plaintiff,
appellant.
defendant,
I am the appellant.
plaintiff, defendant,
Plaintiff.
plaintiff, appellant.
And
Just
also,
a moment. Suit was dismissed.
Suit was dismissed on 22nd February 2018.
Appeal was also dismissed.
Appeal was also dismissed on 28th September 2020.
So, what is the substantial question?
Question is that my lord, the
Where have you framed the substantial question?
I have
A to R तक आपका substantial question of law है। कितना है? A to R मतलब कितना नंबर हो गया? 26, 27 कि 25 substantial question of law frame किए। 25 substantial question of law.
that is mistake.
Mistake.
As because there's so much substantial in this regard, I want to
25 substantial questions of law. Huh?
I want to give a fresh substantial question on law with liberty to the court, my lord.
Essay number 25 or 22. The learned counsel for the appellant has submitted that substantial question of law as suggested by the appellant is running from A to R. He submits that he shall formulate fresh substantial question of law for consideration of this court or confine and file an affidavit. And for that purpose, the matter be posted day after tomorrow.
Day after.
Matter
In
be
next week, my lord. In
Okay.
next week.
The
In
matter
next
be posted on next Monday,
Monday, Tuesday, next Tuesday कर दिया.
next Monday. The proposed substantial question of law be reframed and filed by Friday.
Item 16 second appeal 203 of 2023.
Yes.
Yes, so the present appellant is the original plaintiff who had filed partition suit which was dismissed against which he went in title appeal, and that was subsequently also dismissed. So far as Munad's
What was the ground for dismissal?
yes, Munad's. The ground for dismissal was Munad's that the appellant could not prove that the property that was purchased in the name of the defendant number 1, who is the mother of the appellant, was a Benami property purchased by the father. He could not prove that, and that is the ground for dismissal.
You cannot enforce any right through Benami transaction. That is the law. Correct?
Yes, Munad.
So what is the error of law? What is the substantial question of law?
Yes, Munad. There are three substantial question of law that have been framed by Munad. I have filed separately. Munad.
कब फाइल किया?
29 January.
वहाँ पे क्यों नहीं है अलग से?
I filed both the synopsis and the substantial question of law.
Together.
Yes, Munad.
ये तो आपकी टाइप्ड कॉपी है. Synopsis and substantial question of law इसमें है ही नहीं. क्यों नहीं ये सब लगाते हैं? देखिए सर, आगे पीछे कहीं है अलग से नहीं. हाँ बताइए. I got it.
Yes.
बताइए.
First is that I have framed it. That whether the suit property was purchased by Munni Lal Chauhan, that is the father of the appellant, in the name of his wife, Moteshwari Devi, that is the mother of the appellant. Hence, it is a joint family property at the hands of the plaintiff and defendants on the demise of Munni Lal Chauhan, and the appellant is entitled to 1/7 share in the same. If yes, whether or not the learned trial court and the appellate court has committed either wrong when dismissing the partition and the civil appeal. The second is whether the defendant number 1, Moteshwari Devi, did not have sufficient means to purchase the suit property or make construction thereupon, nor any cogent evidence has been laid to show that she has sufficient means and income to purchase the suit property and make construction thereupon, and that the learned courts below have misinterpreted and misconstrued the provisions of the Benami Transaction Prohibition Act 1988. And the third is whether both the lower courts have wrongly decreed the suit, and that the said deed on the basis of which the defendant number 2 sought relief by way of counterclaim was held by the principle of respondents under section 52 of the Transfer of Property Act, as the same was executed by the defendant number 1 on 24/2010 after institution of suit. Hence, the allowing the counterclaim of the defendant number 2 is bad in law.
What was the counterclaim about?
The counterclaim that was filed with us.
What was the counterclaim for?
Yes. So far as the counterclaim is concerned, that is, the counterclaim was basically about declaration of the property in the name of the defendant number 2 and 4, who are alleged to have purchased the said property from their mother, that is the defendant number 1.
How does that make a difference? As long as the property is held to be the property of the mother, it is
Mulaj.
immaterial
Mulaj.
if the counterclaim is allowed or not allowed.
Yes, Mulaj. So far as Mulaj, the contention of the appellant is concerned, he stated that he had contributed in the construction of the house in question that was purchased by the father, because the mother actually did not have any source of income of her own. So the property was basically purchased in the name of the defendant number one, who is mother of the appellant, by the father, late father of the appellant.
बेनामी वाला नहीं चलेगा ना.
Benami में also, but it has to be established that the funds, so far
Need
as the
not
fund,
be. फंड कहीं से भी आए प्रॉपर्टी खरीदने के लिए, इट मेक्स नो डिफरेंस. जिसके नाम से है उसके नाम से है. द सोर्स ऑफ फंड इज इररिलेवेंट.
but so far as it has to be seen whether the
देखिए वो
contributions.
बेनामी वाला तो नहीं चलेगा. आप जजमेंट पढ़िए. क्या क्या इश्यूज फ्रेम हुआ था पढ़िए. You read the trial court judgment first.
Yes.
दोनों का पार्टी का रेस्पेक्टिव केस पढ़िए, उसके बाद सीधा इश्यूज पढ़िए और फाइंडिंग. It was a partition suit,
It was a partition.
and the scheduled property was the property purchased in the name of the mother.
Yes.
That was the only property,
Yes, that is the only one.
but in case of the plaintiff,
The judgment melons.
trial court.
The present partition suit has been filed.
Next
by-
panel.
Yes, ma'am. The case of the plaintiff in brief is that both the parties are Hindus and are governed by Akshara school of Hindu law. Both the parties are heirs and successors of late Munilal Chauhan. Plaintiff and defendant number 224 are sons of late Munilal Chauhan. Defendant number 5 and 6 are daughters of late Munilal Chauhan. And defendant number 1 is the widow of Munilal Chauhan. Late Munilal Chauhan purchased a piece of land in the year 1991 situated at Mauza, Kurin, PS Sadar District, Ranchi, and the RS Khata number 121, portions of lot number 358 and 359, measuring 4 kattha, more or less. The mohalla is popularly known as Hyder Ali Road, Kokal, Ranchi, out of his own fund in the name of his wife, Moteshwari Devi, defendant number 1, by a registered deed of sale bearing number 1171 dated 13/10/1991. Mutation was done in the name of defendant number 1. A house was constructed over the suit land of late Munilal Chauhan, in which the plaintiff have also contributed some. Both the parties were residing in that house except defendant number 5 and 6. Because after marriage, both of them are settled at their matrimonial houses, municipal records was prepared in the name of defendant number 1 by holding number 861 of 9, ward number 20, present ward number 8, and municipal tax is being paid to municipal corporation Ranchi. The suit premises is mentioned in the schedule A in plate. Defendant number 1 is house building. She is illiterate, having no personal income. The suit land was purchased from self-earning of late Munilal Chauhan in the name of his wife. The suit property is Benami property of late Munilal Chauhan. Munilal Chauhan died on 2/11/2007. Now the parties of the suit has separate mess and kitchen, and they are living in the same house. The defendant have let out 6 rooms to different tenants. The defendants refused to give proper accommodation to the plaintiff on 25/3/2010 when plaster was being done to different rooms of the house, and the plaintiff was forced to occupy unplastered room. The defendants used to quarrel with the plaintiff's family, hence the suit of partition is filed. Written statement on behalf of the defendant number 1 was filed on 17/8/2010, and the written statement cum counter claim was filed on behalf of the defendant number 2. Separate written statement filed on behalf of defendant number 3. Defendant number 4 was debarred by order dated 17/8/2010. Ex parte order was passed against defendant number 6 by order dated 6/12/2010. Rejoinder against counter claim of the defendant number 2 was filed by the plaintiff on 9/11, which was treated as written statement to counter claim. The defendant number 1 stated in a written statement that the suit is fault frivolous, barred by principle of waiver, estoppel and acquiescence, limitation and register. She further stated that the suit is barred by section 34 of the Specific Relief Act and by the provisions of Dynamic Transaction Prohibition Act and by non-joinder of the necessary parties, and also barred by partial partition. The plaintiff left ancestral property and other self-acquired property of late Munilal Chauhan in the instant suit. There was no cause of action, proper court fee has not been given. She submitted further that the suit property has been registered on 31/10/1991 from Gokul Chandra Mathur in the name of answering defendant by her Sridhan with the monetary help of defendant number 2. She admitted the contents of para 1 and 2 of late Munilal Chauhan lose his job due to retrenchment of his employer company. She denied contents of para 4 of the claim. She stated regarding para 5 and 7 of the claim that her name was mutated in circle office structure. Municipal tax was paid by defendant number 2. She denied the contents of para 6 of claim and stated that the plaintiff did not pay his parents. The answering defendant number 1 earned money through sale of milk and other domestic products. The plaintiff was allowed to reside in the suit house in the year 2003 and got permissive possession. The answering defendant sold her property to defendant number 2 Jairam Chauhan. The defendant number 6 was residing with the defendant number now because there was family dispute. She further stated that the company where her husband Munilal Chauhan was employed was shut down and Munilal Chauhan became paralyzed in the year 2002. The defendant number 2 contributed help in connection with medical treatment of Munilal Chauhan and paid rupees 4 lakhs in the first week of June 2005. Later on, defendant extended financial help to the defendant number 1 from time to time. She transferred the suit land with structure in favor of the defendant number 2 and 4 for consideration money rupees 9 lakh. The defendant number 1 further stated that the plaintiff separated his mess after employment and got his proportionate share in ancestral property situated in district Amau, UP. She denied the contents of para 13, 14, 15 and 16 of the claim. The defendant number 2 stated almost same as the defendant number 1 and stated that the suit property including land and structure had been acquired by him through registered deed bearing number 11171 dated 31/10/1991.
Yes, we have seen the plaint and the written statement. We have also seen the issues. What was the relief claimed in para 19 of the written statement? And what was the counterclaim about? The counterclaim was only about the fact that they cannot claim benami transaction.
Yes.
इसके अलावा तो कुछ नहीं था ना. It was hardly a counterclaim. If it is, they have termed it as a counterclaim, but you cannot claim any property to be a benami property. तो बार है. तो क्या है इसमें कुछ नहीं है.
So, we have in lordship so far as the health court and the appellate court did not consider the fact that in the purchase of the property, even the plaintiff had also contributed units. That fact, so far as this is the factual aspect that had not been considered.
Plaintiff had also contributed.
Yes, please.
How much did you contribute and what was the proof?
So far as the documents that have been filed by the plaintiff is concerned,
What was the exhibit to show that you had contributed?
so far as there is correspondence between the father and his father Munilal Chauhan and the plaintiff, wherein the exhibits are there is exhibit 3B Millards, wherein there are certain correspondence wherein their monetary transaction while construction of the house is concerned Those were there also in these correspondences, the letters that they have addressed to us.
Second appeal number 203 of 2023. For the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that suit was filed for partition claiming 1/7 portion of the suit land. In which a house was also constructed, the details of which was given in Schedule A to the plaintiff, and for appointment of survey knowing pleader, commissioner for preparation of septic takta for the plaintiff with cost. He submits that the suit property was purchased by late Munilal Chauhan in the year 1991 in the name of the mother of the plaintiff. And as per the plaint, it was a Benami property, and therefore, after death of Munilal Chauhan, the property was to be partitioned. He has submitted that the specific case of the plaintiff was that his mother had no personal income and she was a house lady and was illiterate. He has also submitted that the plaintiff had also made substantial contribution in the construction of the house over the property. And therefore, the suit property was required to be partitioned. The learned counsel has submitted that the defendant number 2 had also filed a counterclaim on the basis of transfer of property by the mother in favor of defendant number 2 and 4 during the pendency of the suit. The learned counsel has submitted that if the suit property was a Benami transaction in the name of the mother, then under such circumstances, the transfer was held by lis pendens and consequently, the counterclaim could not have been allowed. The learned counsel has further submitted that the correspondences were placed on record to show that the plaintiff had contributed in the construction of the building on the suit property. He submits that the proposed substantial question of law are as under. 15 proposed substantial question of law. The learned counsel has submitted that these aspects of the matter have not been have not been considered by the learned appellate court, and therefore the appeal be admitted on following substantial question. After hearing the learned counsel for the appellant, this court finds that the sole property with the subject matter of partition was the property standing in the name of defendant number 1, the mother of the plaintiff. It is further not in dispute that the defendant number 1, it was claimed in the plaint that Munni Lal Chauhan, the father of the plaintiff, had purchased the property by Benami name of the defendant number 1, and therefore the partition of the property was sought. On the other hand, the defendant number 1 had stated in the written statement that she had purchased the property by her Sridhan and with the help of money from defendant number 2. And the plaintiff was allowed to reside in the sweet house in the year 2003 and got permissive possession. It was also stated that she had transferred the suit land with structure in favor of defendant number 2 to 4 for consideration money of rupees 9 lakhs. And that defendant number and the defendant number 1 also stated that plaintiff was separated in mess after employment and got his proportionate share in the ancestral property in the district Mau at UP. An objection was also raised that the entire property was not the subject matter of the partition suit.
There are two judgments that will be taken on
Which paragraph?
Yes, ma'am. The first is 2001 SSC online Allahabad Form 16 in para 31 minutes and denying the para 31 and at the very last minutes. Herein, in the middle part, the court below were right in raising the presumption that in India, a property is purchased by a Hindu husband in name of his wife, it is to be presumed to be a Benami transaction unless otherwise is shown. Even if this presumption is not taken to be true, then regarding this part I am relying upon minutes. And so far as there is one more minutes, this is Supreme Court judgment 2018, volume 16, Supreme Court, cases 645. Herein I have marked minutes in page number 650, that is para 10, 11, and thereafter in page 61, para 651, that the burden of proving can shift depending upon the circumstances of the cases, because that is what has been dealt with in these three paragraphs.
Read it, please.
Yes, please.
Yes.
In page 650 minutes in para 10, the learned counsel for the appellant has relied upon the decision in Surajit Kumar versus Fuchand, in which this court has laid down that at SCC page 495 para 6, there is no presumption that a family, because it is joint, possesses the joint family property, and therefore the person asserting the property to be joint had to establish that the family was possessed of some property with the income of the property could have been acquired, but it is established or admitted that the family which possesses joint family property, which forms its nature and relative value, may have formed sufficient nucleus from which the property in question may have been acquired. The presumption arises that it was the joint family property and the burden should to the party alleging self-acquisition to establish affirmatively that the property was acquired without the aid of joint family. This is important.
Yeah.
Then para 11. In para 11 notes, in the middle part notes, the burden of proof is not static and may shift during the course of the evidence. Thus, while the burden initially rests on the party who would fail if no evidence is led at all after the evidence is recorded, it rests upon the party against whom judgment would have been given if no further evidence were adduced by either side in the evidence on record. In para 16 minutes, para 16 is stated in the next page 651. The burden of proof is, however, not static and may shift during the course of the evidence. Thus, while the burden initially rests on the party who would fail if no evidence is led at all after the evidence is recorded, it rests upon the party against whom judgment would have been given if no further evidence were adduced by either side, that is, on the evidence on record, as has been held in court in Talwa versus Union of India, and where evidence has been led by the contesting parties on the question in issue. Abstract consideration of honest are out of place and the truth or otherwise of the case must always be adjudged on the evidence led by the parties. This will be so if the court finds that there is no difficulty in arriving at a definite conclusion. It is therefore necessary to weigh the evidence in this case and to decide whether, even if were assumed that there was no conclusive evidence to establish or refute the Benami transaction, that would, on the careful assessment of the evidence, be a reasonable probability and a legal inference from relevant and admissible evidence. Because these things.
आगे the learned counsel for the appellant. अब आप कुछ मत बोलिएगा, कुछ बोलने को नहीं है ना?
नहीं,
बैठिए, प्लीज हैव अ सीट. ऐसे ना डिक्टेशन के बीच में इस तरह से नहीं बोला जाता. आपको आराम से सुने थे. जजमेंट साथ में प्लेस करना चाहिए. मेरा डिक्टेशन बीच में डिस्टर्ब कर दिया, and I forgot that हम क्या लिखा. What is that is actually? ऐसा नहीं करना चाहिए ना. क्या लिखे थे last sentence?
An objection was raised that the entire property was not the subject matter of the partition.
हाँ. The plaintiff had filed, no, the defendant number, the defendant number 2 supported the defendant number 1 and stated that the suit property including land and structure was acquired by him through registered deed of sale dated 31/10/2019 and he came in possession, and the suit property was purchased by defendant number 1 from her Sridhar. The defendant number 3 and defendant number 5 had admitted the content of the plaint and claimed their share in the suit property. Rejoinder, written statement on behalf of defendant number 1 was filed on 17/8/2010 and written statement counterclaim was filed on behalf of defendant number 2. Separate written statement was filed by defendant number 3. Defendant number 4 was debarred from filing written statement by the order dated 17/8/2010. And ex parte order was passed against defendant number 6 by the order dated 6/12/2010. Rejoinder against the counterclaim of defendant number 2 was filed by the plaintiff on 9/12/2011, which was treated as written statement to the counterclaim. Counterclaim पर आपका court fees था? Was it separately numbered? The plaintiff in the rejoinder against the counterclaim to defendant number 2 stated that counterclaim was not maintainable and ad valorem court fees was not given by the defendant number 2. He denied the claim of defendant number 2 and also denied the suit property purchased from Sridhar of defendant number 1. It was also asserted that the defendant number 2 and 4 obtained the sale deed dated 26/10/2010, which was must after filing the suit, and the sale deed executed by defendant number 1 in favor of defendant number 2 and 4 on 24/6/2010 was a fraudulent paper transaction, and as such, the sale deed dated 24/6/2010 was null and void ab initio and not binding upon the plaintiff or the other defendants. On the basis of the pleadings, the following questions were framed by the learned. Following issues were framed by the learned trial court. The learned trial court considered the materials on record and observed and held that or it is liquid. The learned counsel for the appellant has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2018, bracket 2016, SCC 645. Paragraph number. Ten and 11. And also the judgment passed by Honorable Allahabad High Court, reported in 2001, SCC Online, ALL 416.
The Supreme Court has 16 also.
उसमें 16 भी ऐड करेंगे, ठीक है? पैरा 31. To submit that, in a case where Hindu husband purchases property in the name of his wife, it is to be presumed to be a benami transaction unless otherwise it is shown to be. The learned trial court before the learned trial court, it was not in dispute that Munilal Chauhan was the common ancestor of the plaintiff and the defendant. And defendant number 1 was the wife of Munilal Chauhan. The learned trial court ultimately held that the plaintiff was asserting that his father paid the consideration amount and the father of the plaintiff was already dead, and that the element of subsection 2 or subsection 3 of Benami Transaction Act was not proved by the plaintiff, and that it was the specific case of the defendant number 1 that she had purchased the suit property from a Sithan, and she had stated that she had made the construction over the suit property with the help of other sons, and ultimately transferred the property to the defendant number 2 by a registered sale deed. The learned trial court also recorded that the suit property was purchased in the year 1991 in the name of defendant number 1, and the recital of the deed revealed that the vendor received rupees 40,000 from the vendor. The learned Trial Court also took into consideration that under the provisions of Indian Registration Act, recital of the sale deed may be taken in evidence. The learned court ultimately decided the issue in favor of the plaintiff, against the plaintiff and in favor of the contesting defendants. And also recorded that the suit was hit by Section 3 of the Benami Transaction Act. The learned appellate court also considered the materials on record. And held that the plaintiff failed to prove the purchase in the name of defendant number 1 as Benami, and consequently the title of the suit automatically passed to defendant number 2 and 4 by virtue of the sale deed dated 24/10/2010. The learned appellate court considered the materials and ultimately dismissed the appeal. The findings of the learned appellate court. The learned appellate court formulated the following points for consideration. Paragraph 14. The learned appellate court recorded that in order to succeed, the plaintiff had to prove through cogent and reliable evidence that the entire consideration amount of the registered sale deed dated 31/10/1991 was paid by deceased Munilal Chauhan. Number 2, the sale purchase was not for the benefit of his wife, defendant number 1. The learned appellate court also recorded that from the perusal of the recital of the sale deed dated 31/10/1991, the consideration amount of rupees 40,000 by way of demand draft was given by the buyer to the seller, and the plaintiff failed to prove that the recital was untrue and that the entire consideration amount of sale was paid by deceased Munilal Chauhan. The learned appellate court further discussed the materials in internal page 14. इसको quote करो. Particularly the evidence of the plaintiff as under. The appellate court concluded in paragraph 17 that the appellant slash plaintiff failed to prove that the suit property was benami and the consideration amount was paid by deceased father of the appellant. And held that defendant number 1 was the exclusive owner of the suit property. This court further finds that although the plaintiff claimed that he had contributed some money in the construction of the building over the suit property, but neither there was any specific pleading in connection with the contribution. But there was no specific pleading in connection with the contribution made by the plaintiff in the construction of the suit property. This court finds that the plaintiff had miserably failed to prove his case before both the courts that the property was the benami property purchased by his father in the name of his mother. And so far as the counterclaim is concerned, once it was declared that it was the self-acquired property, it was the exclusive property of the defendant number 1. The learned appellate court rightly recorded that the title of the suit property automatically passed jointly to defendant number 2 and 4 by virtue of the sale deed dated 24/10/2010, executed by defendant number 1, even if it was executed during the pendency of the sales. This court finds that there are concurrent findings recorded by both the courts, and no perversity as such has been pointed out by the learned counsel for the appellant in the matter of appreciation of rights. No substantial question of law arises for consideration in this case. Accordingly, this appeal is hereby dismissed. These two judgments, I'll put it and consider it. I have to go through the entire text.
Only thing is that in the plaint and in the partition suit also, so far as the submission that he had contributed money in his recording.
How much? That is not mentioned.
The consideration amount, exact amount is not.
So that is important, no?
Yes,
That is
That
important.
is not recorded,
But it is important that I contributed this much. This is how I contribute. It is absolutely vague.
that is. Obliged.
For hearing, item 17, first appeal CT4 of 2015.
Lord, I am on behalf of the respondent state matter. The file has recently been allotted to me, but that has not been handed over to me. Study itself, madam. I will pray your lordship to grant me some time. After
Cost is cost के साथ आपको टाइम दे सकते
Lordship, we have to prepare list of dates and steps. My senior is suffering from fever. That's why I pray for after.
Why didn't you circulate advance notice? कोर्ट नहीं आए हैं आज. एडवांस नोटिस क्यों नहीं देते हैं? 2 बार आपको कॉस्ट लगा के एडजमेंट हुआ है ना? तो फिर यस एडवांस नोटिस के लिए आपको उनको फीवर हुआ था, आपको फीवर नहीं हुआ था ना? फिर
मैसेज किए व्हाट्सएप पे.
बहुत अच्छी व्हाट्सएप पे मैसेज किए, तो व्हाट्सएप पे मैसेज कर दीजिएगा कि कॉस्ट भी लगा एडजमेंट. ऐसे नहीं होता है ना? इस तरह से हम टाइम नहीं देते. आप पढ़िए उनको सुनने के लिए टाइम. फाइल भी नहीं है आपके पास?
नहीं.
बहुत खुशी की बात. आपके पास है फाइल, आपके पास भी नहीं है.
ना उन्होंने तो बोले कि हमको कल ही लॉस हुआ.
आपका क्या सिस्टम डिफेक्टिव चल रहा है क्या स्टेट का?
Since
Every time the council is appearing for the state.
predecessor's law officer has recently resigned.
Who has
from the
resigned?
post. Mr.
Who has resigned?
Praveen Akhori.
When did he resign?
He resigned, I think, on 19, on Friday. Friday itself. That's why. But issue number 9, just I got the occasion to go through the file under the judgment also under challenge. The issue number 9 is related with the state government. That is for cancellation of Jamabandi. And it has rightly been cancelled by the revenue authorities concerned, and it has been held by the Honorable Trial Court also that it has rightly been cancelled because that Jamabandi was created on the basis of an unregistered document.
पढ़िए जरा. Issue number 8-9.
8-9.
पढ़िए.
तो मेरे पास फाइल नहीं है यहाँ.
दीजिए इनको LCR दीजिए. फाइल भी नहीं है, कुछ भी नहीं है.
8 and 9. 8-9.
पढ़िए सर.
My lord, internal page 8, page number 8, my lord, paragraph 12.
पढ़िए.
Issue number 8 and 9, whether and a deed of settlement was executed on 8/4/1934, and whether by the said deed of settlement any righty interest in respect of the land mentioned therein was created in favor of the settlee, whether Jamabandi number 61 was validly opened, and whether order dated 14/8/84 cancelling the said Jamabandi is illegal and without jurisdiction. That these two issues are main issues for this suit. Hence, taken together for discussion, that plaintiff claimed Raja Manmohan Singh Tikait made righty settlement of land in favor of his son or father of plaintiff, namely Rameshwar Narayan Singh, by executing deed of settlement on 18/4/1934 in respect of 317.82 acres of land under Khewat number 4/9 and 4/10, Khata number 34 to 61, and 35 acres of Moja number 1, in total area 352.82 acre with rightful settlement. The question is here whether Raja Manmohan Singh create a aforesaid settlement for land of 352.82 acre. The land was transferable or not. That case of the plaintiff Raja Kunj Bihari Tikait was Kunj Bihari Tikait by grant of Jodhpeta about the year 1993 had made righty settlement in respect of 345.50 acres of land of Khewat number 4/1 to 4/10, Khata number 20 to 61, and 35 acres of Khata number 1 under Khewat number 2 of Moja, Titulia in his favor. That Chamtu Singh was Khewatdar, not Rayyat. The plaintiff admitted at para 2 of the plaint that after death of Chamtu Singh, his sons Sahib Ram Singh and other became Khewatdar, son of Rayyat. Therefore, son of Rayyat can never Khewatdar. Son of Rayyat can never Khewatdar. It is proved that Chamtu Singh was Khewatdar, that the defendant number 1 to 6 as well as 7 to 10 pleaded in their written statement. Chamtu Singh was a Khewatdar. The defendant number 7 to 10 claimed land on the basis of descendant of late Kunj Bihari Singh, and para 1 of WS 7 to 10 disclosed that Chamtu Singh and his descendant possessed the property recorded under Khewat number 4/1 to 4/10 in tenure right. That the plaintiff has not brought on record the allotted Jodhpatta which he claims the land was settled but Chamtu Singh in Rayyat right. That defendant number 1 to 5 in their written statement at para 12 disclosed that there was no righty settlement made in favor of Chamtu Singh, and such settlement in the year 1893 recorded during last survey record prepared and finally published in the year 1922. That cadastral survey settlement and operation held in the year 1922 as exhibited the descendant of Chamtu as a Khewatdar of Khewat number 4/1 to 4/10 entered in Khata number 20 to 60 Moja Titulia. Therefore, Chamtu Singh was not exhibited as righty right over the land in question. That WS of 1 to 5 disclosed that land of Khata number 61 was recorded in the name of Sheikh Imam Prakash under Khewat number 5, and 35 acres of land of Khata number 4 was recorded under Khewat number 2 of Raja Manmohan of Gair Abad Malik land. That the case of plaintiff in respect of land under Khata number 20 to 61 surrendered the land. Those khatas of Raja Manmohan Singh and further descendant of Chamtu Singh surrendered the land of registered deed of surrender dated 21/11/33 in favor of Raja Manmohan Singh Tikait. That the plaintiff has filed to establish that righty interest in the land of Khata number 22 to 61 was surrendered to the landlord, and land Khata number 20 to 61 was available to Raja Manmohan Singh to make further settlement. That case of the plaintiff and defendants are same regarding righty settlement of 27.668 acres of land twice. The ex-Khewardar to Nalini Kishori Chatwarin, wife of Sahib Ram Singh, Reshmi Kumari Chatwarin, wife of Chamtu Singh, Upasi Chatwari Ghatwari, wife of Bhikhu Singh, Kumari Ghatwarin, wife of Kangulu, by 5 registered deed of settlement number 93, 94, 35, 98 and 104 of the year 1934 dated 7/1/34 that plaintiff admitted the aforesaid registered shell deed settlement in his plaint that land measuring 532.82 acres out of 317.82 under Khewat number 4/9 and 4/10 of Khata number 34 to 61 and 35 acres land under Khata from unregistered deed settlement dated 8/4/1934. That aforesaid settlement deed which is unregistered and produced before court only, photocopy which is marked Exhibit 4.
How photocopy is marked exhibit?
Exhibit 4.
Photocopy.
Photocopy. It was a photocopy and that too was an unregistered one. Unregistered one. The plaintiff are unable to, whatever that the original copy of Exhibit 4 under what circumstances not produced before the court.
They were claiming on the basis of this document only.
On the basis of this, since the document was not registered first, secondly, it was a photocopy of the original one, and original document were never produced before the court below. And this question was also raised by the trial court, my lord, that how and under what circumstances that original copy was not produced. That Exhibit 5, further, my lord, Exhibit 5, Exhibit 11, Exhibit 11A, Exhibit 11B, lawyer of Gangadhar successor appointed himself chairman of the trustee committee of Raiti land in respect of suit land, and Exhibit 5/C was settled by Patta dated 9/4/34 for maintenance of Kunwar Yuvraj Singh, that PW1 deposed para 2 at page 4 in his deposition that every key of his house, whether documents, copy of Sarita Devi and Sapan, and they were under lock, and house, that any living acquisition against defendant number 7 to 10 and defendant number 7 to 10 removed the original documents. This is false story. That the photocopy of Exhibit 4 and unregistered settlement deed is not admissible in the eye of evidence. May kindly be noted, my lord. That the photocopy of Exhibit 4 unregistered settlement deed is not admissible in the eye of evidence. There is no oral evidence produced by the plaintiff that the original documents handed over to Gangadhar by the plaintiff. That PW7 son of original plaintiff deposed at para 21 in his deposition and admitted that he has not seen documents of land, and he does not know about the acquired land, and he is not whispering a single word about anything over the documents to Gangadhar Singh by his father, and there is no any FIR lodged regarding the theft of document. That on examining of photocopy of unregistered Patta Exhibit 4 dated 8/4/1934, that there is deed 9/4/34 available. That backside of this paper, impression of 3 different papers. The Hindi translation of Exhibit 4 which is supplied by the plaintiff is on record. That Exhibit 4 is clearly hit by Section 17 of Registration Act due to unregistered Exhibit 4 as per law.
Plaintiff claimed rayati rights. Khewatdar और rayati में क्या अंतर?
Rayati means to whom it has been settled finally, and who is under possession and just doing the cultivation job. That is the Rayati right. That the right has.
What is Khewatdar?
Khewatdar means he is ex-landlord, being a Jamindar and the landlord, ex-landlord, and he is having that land originally.
Equivalent to landlord.
Landlord.
So plaintiff, they failed to produce the original.
Original,
They were claiming on the basis of unregistered document.
unregistered document.
There was no explanation as to why the photocopy was produced.
My lord.
And in spite of that, the learned court had exhibited the photocopy.
Photocopy. Exhibited the photocopy, but the learned trial court has raised this question.
Yes.
Why the original document had never been produced?
They could have simply rejected it, but still considered it.
And still
rejected
considered.
it.
And discussed about the thing that it is not admissible in the eye of law, section 17 of Registration Act also
सुनिए
was
मैडम,
reversed
आपका
them.
कोई केस नहीं बनता है.
फिर भी देखा नहीं आफ्टर होली लगी फिर भी सीनियर
आफ्टर होली तक बीमार रहेंगे क्या?
नहीं हॉस्पिटल में नहीं है ना इसलिए
हॉस्पिटलाइज्ड है.
नहीं हॉस्पिटल में गए मैं इसीलिए बोल रहे हैं कि आज मेरे को यही बोलने की टाइम ले लीजिएगा उसमें कुछ लिस्ट ऑफ डेट्स और सिनेप्सिस प्रिपेयर भी करना है.
लिस्ट ऑफ डेट्स का कोई काम नहीं होता. फर्स्ट ऑफ ऑल नथिंग इज रिक्वायर्ड.
अगर ये नहीं रहता तो नहीं छोड़ वो अगर नहीं रहता तभी नहीं खा तो हॉस्पिटल नहीं रहता तो नहीं.
तो अभी होली तक छुट्टी मना रहे हैं.
या तो फिर मतलब कुछ दिन
पूछ के बताइए, फोन पे पूछ के बताइए कब आप देख लिए.
डिस्टर्ब नहीं कर सकते ना फोन. हम जस्ट बाहरी बात कर लेते तो हॉस्पिटल नहीं थे अभी
इसको कल रख देते हैं. कल डेट बता
कल छोड़
दीजिएगा.
दीजिए क्योंकि अगर मान लीजिए शाम
कल डेट बताने के लिए रख दें. ठीक है.
इस वीक के एंड में रखते हैं
फ्राइडे.
अगर नहीं होली के बाद हो नहीं सकता तो कम से कम एक ताकि
देखिए फर्स्ट अपील नंबर कौन सा नंबर है ये? 64 ऑफ 2015. MS नाम बताइए.
शोभा
MS शोभा रानी. Advocate submits that the arguing counsel Mr. Virendra Kumar. कौन है arguing counsel? कौन है? नीरज किशोर. The arguing counsel Mr. Neeraj Kishore is not well and therefore he has not come to the court today, and she prays that the matter be posted after holy break. The learned counsel for the respondent has placed the impugned judgment and has referred to paragraph 12 and submits that the core issue involved in the case has been decided by paragraph 12. He has further submitted that the entire case of the plaintiff was based on unregistered settlement deed
Dated 8/4/1934.
dated 8/4/1934.
That is Exhibit 4, which is a photocopy of the.
Dated 8/4/1934. He has submitted that the original of the said document was never produced, but in spite of that, only a photocopy was produced and which was surprisingly marked as exhibit. There was no explanation as to why the original was not produced for the court. He has submitted that photocopy of the document could not have been marked exhibit, as the same would not have constituted secondary evidence also. He has also submitted that as there was no evidence as to why the original was not produced, the secondary evidence was also not admissible. He has submitted that, however, the learned court has considered Exhibit 4 and in spite of that has clearly held that no right would have been conferred upon the plaintiff by virtue of Exhibit 4.
Unregistered.
He has also submitted that the said document was an unregistered document. Since the appellant is praying for time, pose this case for further hearing on 17th of March.
My name may kindly be Miller.
आप अपना मेमो आपके सामने डेट फिक्स कर दी है. आप क्या नाम?
Cause list में
क्यों कॉज लिस्ट में? आपका डायरी नहीं मेंटेन होता?
होता है.
आप अपना मेमो ऑफ अपीयरेंस मांग करिए. इनका नाम लिख दीजिए. इनका नाम?
OP Tiwari.
मिस्टर ओपी तिवारी का नाम लिखिए फॉर द रिस्पोंडेंट। अब उस दिन मत बोलिएगा कि होली के बाद खुला है तो आज हम रेस्ट कर लें। To be taken up at 2:50.
Obliged.
रिकॉर्ड आया हुआ है?